Hello, welcome to another episode of The Lawyer's Tea. Imagine a scenario where you have been involved in a long, grueling legal battle. You've toiled night and day, made different phone calls, filed processes, got dates, adjournments, and it has been a nightmare of a case with the uncertainties left and right. And eventually, get the judgment. The judge's gavel has come down. The curtains are closed. You've gotten the certificate for your judgment in your hand, and you are celebrating. You have popped the champagne. You've called your family and friends. You have moved on in that judgment. You have used that certificate to start processing a lot of things and just moving on with your life. And you are happy. And you are happy that you have put this nightmare behind you. But a few months later, somebody walks into a courtroom, clears their throats and says, "My lord, I think you will overturn that judgment if you hear what I have to say." And all of a sudden, every castle you have built that certificate on just comes crumbling down, and you are back to square one. This is the crux of the matter that we will be discussing today. We're going to be looking at the decision of the Federal High Court to sit on its earlier reached judgment between NDC versus INEC, with now a new interested party, the PNP. With me to discuss this very interesting topic, I have on my right my head of chamber and a very special guest on this show. Sir, please kindly introduce yourself.
Thank you so much. Good afternoon. Good afternoon, viewers. My name is Ayodele, Adepitan. It's nice to be here.
And on my right, we have another friend of the Lawyer's Tea. Please introduce yourself, sir.
Yeah, good afternoon, everyone. It's quite a pleasure to be here once again. My name is Odinaka Eric.
Thank you very much for joining. You may know or may not know, on the 10th of December 2025, the Federal High Court in Lokoja sat on its earlier reached judgment between NDC and INEC, where it had earlier ordered INEC to register NDC as a political party eligible to contest in the next elections. And a principle that has come to play in the Federal High Court sitting on its earlier judgment is a principle of functus officio. This principle simply states that where a judgment has been passed, where the court has said the gavel has come down, a judge has been relieved and divested of every right and every responsibility to sit or hear that matter again. So I'm going to start with my brother at the bar, Mr. Odinaka. What has been violated here? The principle of functus officio has been violated here. Can you enlighten us on how and what gave the court the right and the foresight to decide to sit on this and overturn its judgment?
Okay, thank you so much for the question. I think the principle of functus officio is very clear that once the court has sat on a matter and has reached a final decision, it is relieved of the right or the power to revisit that same case before it. So I think in this particular matter, the court made it very clear that in the order, delivered on on June 26th, that the court is not actually revisiting, the decision or the final decision of the court on the 10th of December 2025. That what the court was trying to do was actually to remedy the wrong made in the earlier decision. But it is right that when a court makes a final decision on a matter, that it is relieved of the power to revisit it. But there are cases or situations whereby a court can.
Please enlighten us on those situations, the exceptions,
exceptions whereby a court can revisit such final decisions when the decision was marred by either fraud, understand clerical errors, or some part of the decision that we are not clearly looked into.
Misrepresented.
Yes, misrepresentations and maybe concealment of some facts. So, but in this particular matter that we are looking at, you understand, flowing from the court's order, understand the court's judgment, it revealed to us that it was not trying to revisit the case based on these issues that we mentioned now. That it was trying to, okay, I know that we've not got into this part that I have to mention Adepitan, but it was trying to remedy the decision that was earlier reached last year, December 10th, 2025.
Okay, I'll still come back to you. Thank you for mentioning ex-debitor. Please enlighten our viewers on what the court meant when it says ex-debitor justicia.
Okay, ex-debitor justicia is applied whereby the court has seen that there is an error in their earlier delivered judgment. So it's trying to remedy the situation. You understand? So the remedy in this case involves the court trying to change the earlier decision. You understand? And to reach a just decision that will favor everyone that is involved in that particular matter. So I think the principle covers is in its entirety trying to ensure that justice is done to everybody. Understand that is involved in the matter.
Okay, Mr. Ayo, this next question is for you. There is one element that screams out with this judgment. It is the issue of fair hearing. Now, PMP claims that they were not able to be heard before the court, and that if the court had heard them, the court wouldn't have arrived at the decision that they did. So I want you to throw more light on the issue of fair hearing, or the authorem partem, and put it in context with the fact that this case has been in court for a while. It was tried to the end of it, and then months later they instituted this action in court saying we were not given an opportunity to be heard.
Okay, thank you so much. Okay, so the doctrine of a fair hearing is enshrined in the Constitution 1999 as amended, particularly in section 36 of 5, which provided that if there is a case against you, an avenue should be given to you to be heard. You should know the offense alleged against you, and there should be an avenue too for you to either admit or to defend yourself, so to say. So that's about that doctrine. And of course, the authority pattern is just the Latin maxim which stipulates what I just made mention of some seconds ago. And going to the issue in discourse, of course, a party to a suit cannot know if a case has been suited against him if he is not made aware of it. And that is why that common pattern that when you file a matter, after filing it, you have that duty to serve the party involved in it. Through that service and acknowledgement, the person will be able to be aware that yes, the case has been set against you. So now you have the opportunity to know when the case is coming up. If you have any process for you to file, you can file. But you doing that is an opportunity presented to you for you to present your own side of the coin, and by so doing, fair hearing is already in play. Now, PMP, in the earlier matter when the judgment was given earlier that they were not party to, they can't be party to because obviously they were not party in that suit. So there is no how they will be able to they will be aware that a case was instituted against them. And even though a judgment has been delivered, and they now later on find out that this has come up, and they now find out that their judgment was against them, and that their interest is not best served, they have seen the right to still approach the same court to still say, okay, yeah, if they have a reason to justify that, if this information I want to give to the court is aware of it before, and the court is aware of it before, and if the court knew that this information, the court would not have entered judgment against them, then I don't think they have done anything
Okay.
outside the law.
Thank
That
you
is
very
that.
much. By the provisions of Section 75 of the 2022 Electoral Act, it makes provisions for a party who has not been registered to approach the court, or to be informed, sorry, of the reason why they've not been registered within 90 days. And it says, and subsection 4 says that within 60 days, a party who has applied to be registered by the commission would be granted a registration status within 60 days, or where they have not been notified within 60 days that they have been registered, that they should deem it that they have been registered. So it gives a 90-day period within which a person is going to be informed that they have not been registered. I draw your attention further to Section 76 of the Electoral Act, which says where a party has not been registered on the ground of identical logo, that such party has 14 days to approach the court for this disparity to be regularized. That the commission makes that provision that they can approach the Federal High Court. Now the PNP came to court to claim that they were informed that the reason for their non-registration was an identical logo. Now they have not approached, they did not approach the court at the time, because if they had approached the court, it would have been an issue of double jeopardy. They did approach the court in time within the 40 days stipulated, and waited for this judgment to be instituted, to be heard and concluded, and then came back after the conclusion of the matter to say, my lord, we were not being heard. This is the reason why this did not take place, and we want this decision to be overturned. Do you think that they can rightly stand on this ground of fair hearing to ask the court to sit down on its judgment and overturn it?
Yes, I think so. And the reason being that I made mention earlier that everything that the court does is in the interest of justice. And justice has to be to all the three persons involved in it. Both the person that sued, the person that is being alleged, and the society, you and I, that we can look at the judgment, read the judgment and say, yes, this really, because what goes around will definitely comes around. PNP, for the record, they were never party to that suit. And perhaps it was when the judgment was circulated, or perhaps when they start seeing the V sign, the OK sign, that's when they now, wait, is that not the logo we use? Maybe that's when they came to be aware of that particular judgment. And that's the reason why, and if they are aware of that judgment, it will still be jeopardy on their own side for them to sleep on their right and not say approach the court and present that fact before the court that this logo belongs to us.
But
so I don't think they have done anything wrong in that.
Barrister, let me hear your opinion on this, please.
I totally think that they've slept on their rights, because this registration we are talking about was effected on the 23rd of February 2026. That's after the court had delivered that judgment on the 10th of December 2025 that NDC should be registered by INEC. So you cannot tell me that PNP as a party are not aware that they did not hear, understand, or they've not seen NDC going about they are declaring their intention, because the NDC actually wanted to project a party for this national election coming up next year. So they cannot say that we are not aware of all this that happened. And speaking of INEC, I think they are the proper party if we are talking about the issue that was instituted against INEC by NDC. Understand? Last year by NDC.
Yes.
The matter, the core of the matter was for NDC to be registered as a political party, and they fulfilled all the conditions. They've met all the conditions that warranted them to be registered as a political party, as provided by Section 222 of the Constitution of the Federal Republic of Nigeria as amended. So I don't see any reason why the court should not have gone ahead to understand direct INEC to register them as a political party. So PMP coming after the court's order directing INEC to register NDC, praying the court to set aside such judgment does not sit well with me. I don't think they have totally slept on their rights, and it should not be heard saying that they were that justice was not done to them.
Yes.
By the mere fact of the fact of the fact that the court made judgment in their absence.
I think when we're looking at this, we're not looking at this in the light of which party, or we're not being partisan. When we're looking at judgment, we should actually, I mean justice, we should actually be looking at what does the law provide. Justice cannot be outside of the confines of what the law provides.
No.
And if the law that says go to court if you have not been registered says you can go to court within 90 days, you can go to court within 14 days, and you wait. When did you say that NDC was registered?
23rd of February 2026.
That's when they applied, 23rd of February, and they got judgment in December. How many? That's about 10 months.
So are you expecting them? Are you expecting individual? We are all lawyers. Are you expecting that the judgment that came that was decided today in the various courts, that I, for one, as I'm seated there, I will be abreast of all of them?
No, that's not. That's
so
not
it is
the issue.
it is when issue arises that concerns you, that you pay attention to it.
Okay, I think
our point is why did PMP not approach the court?
Okay, I think
it is not our place to question
why they don't slept on their rights to be heard.
But of course, we are humble. If the law stipulates period for you to approach a court. Also,
my colleague saying that we don't expect the lawyers for PMP to be aware that there was a judgment.
I didn't say lawyers.
Okay.
I didn't say lawyers.
Okay. Because I'm aware. I'm aware that the association. I'm aware that the person that instituted this that filed this motion is their legal advisor. You understand? So I'm very okay. Let me not use the word very certain, but I should believe that he will be aware of the judgment delivered by the court.
And that was really why he acted.
But okay, just as you mentioned, I don't understand why people would also want to believe that NDC are aware, because the facts are not before us, that they are aware that PNP already submitted this logo. Because INEC did not make this fact known to the court when
they were asked.
When
the matter was the issue.
You know, when I was making my introduction the other time, I said due diligence. Due diligence. You can see that word it might be small, but it has a lot of things to do. No.
Is it in the place of NDC to do due diligence when they submit?
I didn't know that I was suing. They have to do their due diligence.
Double-edged sword. They have to do their due diligence.
And now, you see the position we find ourselves. What they don't want to do earlier. Now we are in it now.
The point I'm trying to make is that NDC brought INEC to court and prayed the court for INEC to go ahead and register them. INEC never brought any fact or submitted any fact before the court that this is the reason why we
is that not their due
diligence?
Can't you say that that's their due diligence?
INEC did not make it bare before the court that the reason why they did not register NDC was because there is a conflicting logo before them.
And now, every case has its own lifeline. I wish we have copy of that process before us here, so that we'll look at it line by line. If that's not an issue, part of what they pray for, are you expecting INEC for them to work for INEC now say, of course. Yes, so I'm just of the opinion that I'm not holding the brief of INEC, and neither am I holding the brief of NDC. But who knows if what they pray for is what INEC responded to?
The truth is that what NDC, from what we read, you understand, what NDC prayed the court was for court to order INEC to go ahead and register them as a political
without not asking the court whether to make inquiry as to the reason why they were never registered in the court. Good. And that's so if it's not in their place, then why would INEC now come and
ask me the parties that were supposed to be in that matter is INEC. I do not see PMP. I don't see the necessity for PMP to be joined as a party in that suit.
We all know that. So once a party have interest in the case, the law is clear that they can join. They can apply to the court for them to be joined.
So, as it happened that they are not aware, okay, like, just like you said that you are not holding the brief of INEC, neither are you holding the brief of NDC. But from the facts that we have before us, we have not been told that NDC, we are aware that PNP submitted a similar logo as theirs. You understand? Before they approach the court for this registration.
Perhaps because of lack of
that happened,
diligence.
yes, if that happened and INEC did not challenge that particular fact before the court, and the court went ahead
to grant
the order for them to be registered.
Based on the fact presented to the court as at then, and now new facts now emerge through a party, an interested party that sought the court to be joined. So if you did A and later you now find out that because the reason why you did that A was because you are not aware of B, you have to reverse and what and sort it out. That was what that Latin came up on.
I think we'll keep going back and forth on this issue, and I will throw it open to our viewers to give your opinion. The facts of the case remain that the provision of the Electoral Act is to the effect that if you have not been registered, you can approach the court. One party approached the court, one party was giving judgment, another party slept on their rights, woke up after judgment had been given and said, I was not properly heard.
And still approach the court.
And approach the court. Well, you won't say that new facts arose, because these were facts that were already there. It just wasn't disclosed. And it's not the place, you can't rightly say that it is the place of NDC to disclose facts that are within the knowledge of INEC. They are not the registering party. They are not the registering commission. It's INEC that was supposed to disclose this fact. INEC did not do that. But who is bearing the brunt of it now? NDC.
And
when they are supposed to be... Well, I don't know about PNP because PNP doesn't seem like a party that wanted to be a party in the first place. After staying so long.
Because
I believe that they are serious.
Section 79 of the Constitution, of the Electoral Act, equally stated that if you want to register as a political party that want to contest in the election, you have to register before 12 months.
And that was really why they applied to
that
INEC.
Was really to show that NDC, we are really interested.
Not only NDC, even PNP was interested. That was the reason why they applied. That was the reason why they applied.
Why didn't they move
because it's painful when you apply to a commission and the commission don't register. It's painful. You know the trauma involved in it.
This takes us back to your question. Whether they slept on their rights.
They did not.
They did not.
I didn't mean they are serious.
Because they were informed.
They should have gone earlier than now.
To approach the court.
They did not. They became aware when they found out about that judgment. That was why they approached the court. Instead of them to want to now duplicate that suit and now approach different court, they still deem it fit to approach that same court to carry a decision.
I think you are not getting the facts right. They were not informed when that judgment was. They were informed prior to that judgment because they approached the court saying, we have facts that will make you change your mind.
After the earlier judgment had been delivered.
After the earlier judgment. So they knew the reason for why they were not being registered. And the act says, approach the court within 14 days. So they didn't approach the court within 14 days. They didn't approach the court within 30 days. They didn't approach the court within 2 months. They approached the court after a judgment, a matter had been instituted and heard till full judgment. And that was when they approached the court. You can't say that they didn't sleep on their rights. Well, I will take us to our next question because we'll sleep on this if we are allowed to.
I'm not going to sleep on our...
So in this event, what do we think are the options open to NDC? What options can they explore? And if you are towing the route of appeal, what do you think are the grounds that appeal should come under? I'll start with you, Best.
Okay, thank you so much. As it stands now, what the option they should explore is to appeal the decision of the court. Understand? And in that they appeal, what they should be seeking for is for the court. Understand? Whichever the court of appeal, I'm talking about the appeal court now, to uphold the earlier judgments that declared them to be registered as a political party as the rightful judgment. Understand? Because it was delivered on merit. As that's my view, that's my humble submission with regards to this. And if you ask about the grounds that they should be coming under, they met every condition necessary for a political party. When you are talking about two-finger logo, nobody owns the two-finger logo. So long as they submitted this logo, this symbol before INEC, they've met the necessary condition. You understand? That is required of them to be registered as a political party. So in view of that, I believe they have what it takes, understand, to have the earlier judgment delivered being upheld. But we have to really look at the legal stance as it is now, because this same court, this judgment that we are talking about has already been set aside by the same court that delivered it. So it is going to be a very tough one, in my own view and in my own opinion. So it's going to be a very tough one for them. It's a political party.
Barrister, do you have a contrary opinion?
Yes.
Or anything to add?
Yes, regarding that, of course, I'm after the right thing. If NDC did the right thing, court should give them judgment. And if PNP did the right thing, court should to give them judgment. Of course, as it stands today, the judgment that was being appealed against is that of the latest one that quashed the earlier decision. And that was what NDC appealed against. And now, if the material fact indicated that PNP are the first party to submit the two-finger logo to INEC, that means they are the original party or the right person or the political party to use that logo. You can't say the second person that want to use that now, the court should now look at it and give judgment in the favor of the person.
Okay.
Because the first in time,
I don't have any issue with the first in time.
Yes.
The issue I have is that it might be true that you submitted this logo before I did. But understand, for the fact that the commission did not register you and deemed it fit to register me, understand, first, I'm the first political party, understand, to register with that logo. You get, so as it stands now, they've already been registered as a political party under that logo. So they cannot claim ownership to two-finger.
Well, I want to mention something.
Before you mention, it will still keep us taking us back to what has happened earlier, because even though on record the court delivered judgment on the two-finger logo because NDC was one that approached the court first, but if the court was aware that it has been used by PNP and because of application, the court would not have, and that was what came to play, and that's the reason why the court quashed its own judgment. So we cannot say because of that we cannot progress in error, and that was what the court remedied. And thank God we are before they are before the court of appeal. So let the court of appeal look at the case, the appeal before them, crystally, and come about judgment. Who is the right party to what? Because it's merit that all of us are looking for. Nobody is whatever, but if they approach the INEC first and all, I believe that, and of course, from the beginning, if peradventure they have approached the court first, the court will not have given judgment to NDC.
But they slept on their rights.
Yes, sir.
But let me bring your attention.
And that is why the court is there to remedy whatsoever, to project any person that will sleep on their right or that is awake or walking on their right.
Equity does not aid the indolence. Let me bring our attention to section 79 or subsection of the 2022 Electoral Act, which was the act in force at the time this matter was instituted. It mentions that where a political party has been deregistered, although we can say it was not a deregistration or whatnot, but it mentions that when a political party has been deregistered, its political name, its symbol, its colors, its logo cannot be used for the next 5 years. So what is the purport of, because the reason I'm mentioning this is because I understand the heart behind, I will apply the golden rule to this thing, is so that another party is not mistaken for the deregistered party. So it just to bring clarity to the voters that this is the party that, and let there be no mistake of identical or mistaken. So what now becomes the purpose of if the appeal says the PNP should be registered with the double logo sign, is this not going to bring sort of a confusion? And can we also say that this 5 years rule should apply in this instance? Because we can claim that it's a, but the truth is that the NDC has been known with that logo sign, either through the gamut of this case, or from campaign, or from some printing of materials and all of that. The person has been known with this sign for now, or that was registered prior to the court saying we've done to status quo antebellum is NDC. So can we actually say that giving judgment to PMP to say, oh, PMP should be registered with that logo, is that not going to bring a confusion in the electoral process?
I don't think it will be seen as the registration, because the court was very careful in its wordings when it delivered the ruling. You understand?
Yes.
That set aside its earlier judgment. It did not state that NDC is the register. When it said status quo, it means that it should go back to the position where they were when they approached the court.
As a non-registered
party.
Yes, to be registered as a political party.
I agree.
So I don't think this section 79 of the Electoral Act 2022
yes.
would apply to PMP, Peace Movement Party, if they eventually get judgment in their favor to be registered as a political party. They can still go ahead to.
But would it not occasion an incident of mistaken identity?
Not at all. Not at all. Because as it stands, both in the legal world and even in the, it shows that there is no party in Nigeria political space that has autonomy of that party or that logo yet, until the court pronounce it, because it's an issue in dispute. So we'll wait whenever they, because I believe that the matter was taken to Supreme Court. Because whoever win or loses at the court of appeals, they want to. So I'll wait until the finality. Whoever is being accredited with that logo, then that will be.
I'm saying, would it not occasion in an issue of mistake for the voters?
No,
I'm not talking about
it will not now, because
for the voters.
No, it will not, because of course both the voters, the supporters of PMP and NDC, they have been claiming that they know that yes, this is the logo of their party. So it will not, because of course the voters they are not I don't want to say, of course, even though we still have some uneducated voters, which is where we are going to. Of course, it's not going to be an issue to the educated voters, but to the uneducated voter, it is the place of the political party now that will eventually use that logo to educate their supporters.
Okay. Lastly on this, I think a lot of issue has been made on the public space about the party not being a juristic person. Just as a closing, can you make comments on that? As lawyers, we understand why the party, how the party sued, but I think you should enlighten our viewers on how and why either PMP and NDC, not as a juristic person, was able to bring an action before the court of law.
Okay, if I'm to address that, the act that bets or that gives right to any of the political party is the Electoral Act, and as we speak now, it has been amended this year. So, but once a political party shows interest and they apply to INEC, which is the registration body now and regulatory body, so to say, and the registration is successful, that political party has become a juristic person, so to say. It can sue and be sued to have a common say and otherwise. So that is the aspect of that. So all what they just need is just to find merit with the electoral body, and once they are registered, they become a good.
In this instance case, both parties were unregistered. So where do they draw their legal
I think they see
from?
in a representative capacity.
Yes.
When you take a look at the
processes,
parties,
yes,
you understand the process. You see that they sue in a representative capacity on their behalf. Sorry, in their name and on the behalf of their political parties.
Yes.
You understand? So as it stands now, both of them are not both parties talking about NDC that are unregistered. They are not a juridical person.
Yes.
So they cannot sue and be sued in their names. You understand? Then I will equally add to this. I think it all becomes on both parties. They can decide to equally. I don't think out of court settlement is
out of place.
Yeah, is out of place in these matters.
Because they have common interests.
Yes.
To participate in the general election.
Yes.
So if that's the core mandate that they have from beginning,
yes,
they I don't think. Because it's just a minute, I think it's a minute issue that they can really settle.
Yes.
Because what they are talking about is that they are not contesting the fact that they don't want to participate in the election, it's just the logo.
Yes.
So they can come and say, okay, whatever, if it's to choose another logo and not, because a lot of life are dependent on this.
Yes.
count how many millions of naira that have gone through the lane, because each of most especially NDC, they have I think I can't talk about the figure now, but I know that they have hundreds of they fill up almost all the position.
Yes.
That offer election for license, starting from the presidency, the National Assembly, the House of Assembly, and the governors. And if you count it, there are more than 100.
Yes.
So, because those people now, their fate is in their hands of their leader,
yes.
Because they don't know what will happen. If peradventure now court say otherwise to NDC, that means people are a lot of resources have been wasted, a lot of energy and what have you, and the same thing. So I don't know about PAP now, whether they have filled any party, so they might be the one that will be smiling. So for the interest of justice that NDC are claiming to be a week of, they should meet with PNP
and explore out of court
settlement, which is one of the things, because whether you get a court judgment, at the end of the day, it will still be adopted in court, yes, as a court sponsor judgment of the court. So it's a win-win situation for both of us.
I sincerely appreciate you both for your inputs, your insights into this. As we continue to watch our judicial system to see the outcome of this very, very crucial and impactful case, we hope that justice will be done and to be said to have been done. And we hope that this does not mar the future of our forthcoming elections. And to you, our viewers, my final statement to you is all these pre-election issues will happen, are bound to happen, and even post-election issues will happen. Do not be perturbed, do not be discouraged. Take your right to vote as one of the most important things you can do for your country. It's said that ask not what your country can do for you, but what you can do for your country. A better Nigeria starts with you, starts with me at the polling units. Take your voters' rights seriously. Let's come out in mass to vote and decide on the future of Nigeria. Thank you very much for watching. I remain Barrister Princess Ajilore. Thank you very much.